Hello, this is Allison, Shelton, and Beth Ann Jackson, and we are so excited to have you here with us today to go through this webinar, Preparing for the Inevitable, Best Practices for Investigating and Responding to HIPAA Security Incidents and Breaches. Both Beth Ann and I are members of the healthcare group at Brown & Fortunato, and we spend 100% of our time on healthcare issues and healthcare clients, and so this is our bread and butter and something we are passionate about if you can be passionate about HIPAA. So I hope this presentation is beneficial to you, and we'll get started because we have a limited amount of time. So the first topic that we are going to have is, what's the likelihood? Why do you need to be concerned about HIPAA breaches? And one reason you need to be concerned is because of today's day and age with multiple cybersecurity attacks and the fact that HIPAA can be complicated, and it's just one more thing that providers have to worry about. And so it hasn't been, some providers have put it on the back burner, which is evident in the recent OCR 2017 desk audit, which found that 94% of our organizations had inadequate risk management plans. 83% of organizations had performed inadequate risk analysis, and 89% of organizations were inadequate on patients' rights to access their PHI. So the risk is quite high of a breach, especially based on the poor performance of organizations, and as evidenced in this desk audit. The fact that most organizations are failing to conduct appropriate risk assessments leaves such organizations vulnerable to breaches, especially in this day and age of ever-changing cybersecurity threats. Studies have shown that in a 2-year period, there's a 90% chance of a data breach, and half of the organizations that will have one breach will actually end up having more than 5 breaches in that 2-year period of time. The 6th annual benchmark study on privacy and security of healthcare data found that almost half of breaches were caused by third parties, such as business associates. However, a significant amount of breaches experienced by both covered entities and business associates were caused by unintentional employee conduct. I can't tell you how many calls I've received where the provider says one of our employees had to run out they left a laptop or they left a file in their car. Their car got broken into. Do we have a breach? It's something that happens repeatedly, and so, and depending on the circumstances, such situations can turn into significant breaches. So with that, I'll turn it over to Beth Ann, who will discuss whether or not breach is a 4-letter word.
No, actually, it's a 6-letter word. So it's important to understand and have the right perspective regarding HIPAA breaches and reporting obligations. While you need to take substantial efforts to avoid breaches, and they are always unwanted, they're becoming a fact of life, as Allison said, with the constant cybersecurity threats from both domestically and internationally. But it's important to understand that a breach is not the same thing as a HIPAA violation. If you are able to produce documentation showing that you experienced a breach but you handled it appropriately, it's unlikely that you're going to be fined by the Office for Civil Rights. The fines and penalties typically arise when you fail to comply with the HIPAA privacy and security rule, including the requirement that you investigate, report, and respond to any breaches. So a case in point is Presence Health. It's a good example of a case in which a healthcare organization was filed for failing to timely report a breach. So they discovered that paper-based operating room schedules that contained protected health information, and for the sake of us all, I'm going to call protected health information PHI, so I don't stumble over my words. So involving 836 individuals were missing. 3 months after discovering the incident, Presence Health reported the incident to OCR. Now, they had an obligation to notify the affected individuals, the media, and OCR as soon as possible, but no later than 60 days after discovering the breach. When the OCR investigated the incident, they determined that Presence Health failed to comply with a 60-day time frame, and Presence Health agreed to settle OCR's claims for $475,000. So just for a 30-day delay, they ended up paying almost $500,000. So it's notable that it wasn't the breach that was the source of the fine. Rather, it was the entity's failure to properly and timely respond to the breach that caused the $475,000 fine and the OCR investigation. So here we have a lot of information on the civil penalties. We want to emphasize that the fines listed on the slides are for violations of HIPAA, and that is not the same thing as the occurrence of a HIPAA breach as described in the Presence Health case. Violations can include things like failure to have compliant business associate agreements in place with your vendors, if necessary, failure to conduct a security risk assessment and to implement a security management program in the first place, and failure to update them, and failure to adopt policies and procedures under the HIPAA privacy and security rules. HIPAA provides for both civil and criminal penalties for violations. Criminal penalties are typically things like an employee stealing Social Security numbers and selling them so that people can commit identity theft, and things like that. But civil penalties are far more common and are what we have outlined here. So there are 4 tiers, and if you didn't know and couldn't reasonably have known of a violation, the minimum penalty is $100 and up to $50,000 per violation, with a maximum of $25,000 per year. Now, you'll notice that the per violation cost exceeds the $25,000 maximum per year, and that's because they just changed that. So for Tier 1, you won't get a $50,000 fine. If the covered entity was not neglectful and there was a reasonable cause for the violation, then the OCR can fine the entity between $1,000 and $50,000 for each violation, up to $100,000 a year. Willful neglect is going to result, but if you correct it within 30 days after discovery, results in a fine between $10,000 and $50,000 per violation, up to $250,000 per year. And finally, the ultimate penalty is if you willfully neglect your obligations and fail to correct violations, you can get $50,000 per violation and up to $1.5 million per year. So at the end of April of 2019, so just last month, OCR announced that it would exercise additional discretion in applying regulations regarding the maximum fines. Previously, regardless of the covered entity's conduct or knowledge, they could be fined up to $1.5 million for the same kind of violations occurring within a 12-month period. So this drastically reduced the cumulative annual limits depending on the tier of the violation. So that is important. Next, we're going to talk, Allison's going to talk about identifying a breach. Allison?
And one thing I wanted to point out on the previous section as far as the difference between a breach and a violation, what we see happen is if you have a significant breach that results in a report to OCR and to individuals and to the media, one of the first things that OCR will turn around and request from the provider is, give us a copy of your risk assessment and your risk management plan. And so, as you saw in the very first slide, over 90% of the organizations aren't keeping up with their risk management and risk analysis plans. And so that is something that is crucial because it helps protect your organization against these, like we've discussed, ever-increasing cybersecurity threats. So you're aware of where those weaknesses are, and you can put in place corrective plans to minimize that weakness. And failure to do that is a violation. And so while you may be a victim of a email that then spread the virus through your computer system, while that's caused by another outside entity and you are a victim, you could still be fined if you haven't put in place those risk management plans and those risk analysis and you're keeping that up to date. And so that's one thing to be aware of is if you had that risk management plan and you could then turn around to OCR and show them we are doing all we can to protect this organization and yet we're a victim, you're more than likely not going to be fined because there's not going to be a violation. But if you don't have that risk management plan and that those risk analysis up to date, you could be fined for violating HIPAA. So next we're going to talk about how do you, if you are aware of a particular incident or a potential breach that has occurred, how do you know if you've crossed into, is it actually a breach that has to be reported? So HIPAA defines a breach as an unauthorized acquisition, access, use, or disclosure of PHI in a manner that is not permitted under the HIPAA privacy rule and that compromises the security or privacy of that PHI. Based on this definition, there are 4 key questions that need to be assessed to determine whether a particular incident, a particular circumstance is truly a breach. First, was there an unauthorized acquisition of, access to, or use of disclosure of PHI? Second, was the PHI unsecure? Third, does an exception to the definition of breach apply? And fourth, can the entity demonstrate a low probability that the PHI was compromised? We will take a look at each of these questions independently. So the first question, was there an unauthorized acquisition of access to or use of disclosure of PHI? To answer this question, there are some key terms that really need to be understood. The first is protected health information. Protected health information, or PHI, is broadly defined, and it includes information that either identifies an individual or could reasonably be used to identify an individual. So initials at times can be reasonably used to identify an individual. To be PHI, such information must relate to the past, present, or future physical or mental health of a condition of an individual. So that could be as simple as this person was an inpatient, or this person was an outpatient. It has to relate to the condition, the provision of health care to an individual, or the past, present, or future payment of the health care to that individual. Another term that needs to be understood is the term unauthorized. To determine whether a particular incident is unauthorized, you must be familiar with the permitted ways that PHI may be acquired, accessed, used, or disclosed. This includes a number of things, such as allowing individuals access to their own PHI or using or disclosing PHI for the covered entity's own treatment, payment, or healthcare operations. Anything that's expressly permitted under HIPAA is an authorized use. Therefore, not being familiar with those permitted uses allows you to determine whether or not an access was unauthorized. Also, the terms acquisition, access, use, and disclosure each convey a unique action that need to be understood. I've found that the nuances of these terms are especially important to consider when assessing a proposed plan that may involve PHI, and you're not quite sure whether or not you're towing the line. For example, I've had a client that wanted to develop a spreadsheet of patient email addresses and then use that spreadsheet for marketing campaigns. They were planning to connect with Facebook. Facebook has this technology where you can submit email addresses. Facebook then connects that with their Facebook users and helps do targeted advertisements. I'm sure if you're a Facebook user, you're familiar with this. I'm always surprised whenever I get on there. Some site that I was shopping for a cow chat all of a sudden has an advertisement on my Facebook feed. So there's this savvy technology that this particular client wanted to make use of. And so while the email address in and of itself may not necessarily be PHI, because not all email addresses clearly identify the individual, it doesn't relate to the past, present, future healthcare of that person. The fact that my client had to access the patient's intake record in order to get that email address is what we had to look at. Was that access an authorized access of that file for this purpose? If it's not, it's a breach. If it is, then we're not worried about breaches. So in sum, the definitions of these terms may be very relevant when you are trying to determine whether or not a breach has occurred. So we're going to look at a particular case that shows that even if everybody knows what has happened and knows what you're talking about, you still can't use PHI. So we should all learn from this case from Memorial Hermann. In 2017, Memorial Hermann paid $2.4 million to settle a claim that it had a HIPAA breach. In this case, a woman presented a fake driver's license to the hospital when she checked in. The woman had been residing in the U.S. for more than 10 years, but was not authorized to be in the U.S. So when the hospital staff received the ID, they thought it was fake, and they went ahead and contacted the Harris County Sheriff's Office, which was appropriate, and ultimately the woman was arrested. The incident exploded. The woman retained an attorney, and together they motivated protesters and immigration activists. It was all over the news media. The hospital was assuaged with protests and questions about its report to the sheriff's office and how it handled this particular situation. So the Memorial Hermann decided to do a press release. And in the press release, the hospital responded to the allegations and mentioned the woman's name, which was already publicly known because this woman had gone to the media, had done interviews on various news sites. Nevertheless, because the hospital did not have the woman's consent to release her name in its press release, the hospital committed a breach. So even though everybody knew who the hospital was talking about, the fact that they released her name without her consent and used PHI in that manner was unauthorized. The second question that needs to be assessed when you're trying to determine whether or not a breach has occurred is, was the PHI unsecure when it was acquired, accessed, used, or disclosed? PHI can be secure if it is either appropriately encrypted or properly destroyed. To address whether PHI was secure, it is essential to understand the limits of encryption technology that was applied to the PHI at the time of the incident. OCR has cautioned that depending on the circumstances, such technology may not actually render the PHI secure. For example, laptops containing PHI are often stolen. If that laptop has full disk encryption and was powered on and in use at the time it was stolen, that full disk encryption will not be sufficient to encrypt the data because the laptop was active at the time. But if the laptop had full disk encryption and was powered off, then the PHI would likely be secure and no breach would have occurred. So when you are dealing with electronic PHI and determining whether or not that PHI was secure, it's really important to understand the limits of your encryption technology and to what extent that encryption technology applied to that PHI. Question number 3 is, does an exception to the definition of breach apply? HIPAA's breach notification rule specifically excludes 3 types of situations. First, when one member of a workforce unintentionally acquires, accesses, or uses PHI when done in good faith and within the scope of that person's authority, and it does not result in any further inappropriate use or disclosure, then you have an exception to the breach. For example, if a nurse inadvertently opens the wrong patient's file, this access is not authorized, yet it's an exception to the breach because this was unintentional and it's not going to result in any further inappropriate use. The second exception is when an inadvertent disclosure of PHI is made by one authorized person to another authorized person that does not result in any further inappropriate use or disclosure. We see this often, for example, where a provider faxes the wrong patient records to the office of a physician, or they fax the patient records to the wrong physician who is a provider on their medical staff. Oftentimes that type of situation will qualify for this exception. And a third exception is when the entity has a good faith belief that the person to whom the PHI was inappropriately disclosed would not reasonably have been able to retain the information. This exception is also potentially applicable. For example, let's say a hospital faxes the records to a physician, but the physician's not on their medical staff. It doesn't qualify for the second one because that physician, if they're not on the medical staff, isn't part of the hospital's organized healthcare organization, yet that physician that's not on the medical staff is still a covered entity. It should still have in place HIPAA policies and procedures, and is unlikely to result in any kind of use of that record, and understands that they should not jeopardize that information. And then the last question is, can the entity demonstrate a low probability that the PHI has been compromised? So this standard back when in 2013, when the HIPAA rules were modified, this was a new modification. So previously, the providers had a little bit more leeway on concluding that, yes, a breach has occurred, but more than likely there's not going to be any kind of harm resulting from this breach. Now there is a presumption that there is a compromise of that PHI unless you can demonstrate, meaning some evidence, something factual, that you can build your case on and show, no, this, even though a breach has occurred, there is a low probability that the PHI has been compromised. So when you're doing this analysis, there are 4 key factors to look at. 1, the nature and extent of PHI involved, including the types of identifiers and the likelihood of re-identification. For example, if the PHI that was disclosed included social security numbers, dates of birth, the nature and kind of the insurance information, this type of information is more than likely to be used to harm that individual. So it's a factor that would lean to, you're more than likely not going to be able to argue that there's a low probability of harm. Second, you need to look at the unauthorized person who used the PHI or to whom the disclosure was made. So let's take an example of you have a couple of friends. You have Betty and Nurse Tom, and Betty knows that her friend Sally was admitted to the hospital, and Betty really wants to take her some food, but she's not quite sure if her friend has any dietary restrictions. And so she goes to Nurse Tom and says, "Hey, I want to take my friend some food. Do you mind just checking to see if she has any dietary restrictions? I can't get a hold of her on her cell phone." And so if you find out that Tom accesses Sally's file, then you have an unauthorized access of that file. But if you intervene and are able to tell Tom that if he uses that information inappropriately, then there's a HIPAA breach and he could be sanctioned under the HIPAA policy, and Tom affirms that he will not use that information, then you probably have a good case to argue that, to demonstrate that there's a very low probability that the information that was inappropriately accessed resulted in a breach. Because 1, Tom is a nurse and under your control and under your supervision. Another factor to look at is whether the PHI was actually acquired or viewed. It is possible that PHI could be accessed, but that it was never acquired, retained, or even viewed. And so if you can demonstrate that, then you may be able to build a file to demonstrate that there's a low probability of compromise of that PHI. And then finally, you need to look at the extent to which the risk to the PHI has been mitigated. For example, in our case of Tom, Nurse Tom, who looks at Sally's file, if you document in your personnel file that you intervened with Tom, and then Tom signed an affidavit recognizing that the appropriate use of PHI and that any use or disclosure of the information that he received would be a breach, and he confirms he will not, then you will have evidence that you mitigated the situation. And again, you can build a file, build a record, documentation that there was a low probability of compromise, and therefore the breach does not need to be reported. And that brings us to our next topic, which Beth Ann will discuss, and that's what are the reporting requirements when a breach is identified.
Hello again. One thing we haven't discussed yet, and which covered entities should consider, is cyber liability insurance. And one of the reasons is if you have a large breach, the reporting requirements and the other requirements that and all the different elements of that, including like the establishment of an 800 number, it can be a lot to undertake. And so a lot of cyber liability insurance policies will help you, guide you through that, and they'll actually have preferred vendors that have done this and that do this on all the time. So it can really be very helpful. Also, if you don't have that, you definitely want to talk with legal counsel regarding your responsibilities to make sure, first of all, that you do need to report, and second of all, that you do it in a timely manner. So once you determine that a breach has occurred, whether it was caused by someone in your organization or by a business associate, then there are federal requirements for you to report the breach. Those include notice to the affected individuals, notice to OCR, and perhaps notice to the media regarding the breach. Now, this is where you need to pay attention to the provisions in your business associate agreement, because if you only get notice from the business associate, after 30 days, that gives you a very short window in which to provide notice to the affected individuals. You also need to review state laws to determine whether additional obligations exist where the affected individuals reside and where you do business. And we'll talk about the laws that are applicable in Texas later in this section. So with respect to individual notice, when a breach occurs, you need to notify affected individuals within as soon as possible after discovery, but in no case more than 60 days. As we said before, Presence Health waited 90 days and they were fined for that. The notice has to be in writing and sent by first-class mail, or it can be sent by email if the individual has agreed to receive electronic notice from the entity. I don't find that typically occurs very often, but it's an option. In cases where you don't have good contact information for affected individuals, you can do a substitute notice depending on how many individuals that you don't have good contact information for. And a lot of this will depend on how old the records are. You could have records in Iron Mountain from 20 years ago, and something happens there when you're pulling a box and it falls off a truck on the way to you, and and you'll have to notify everybody in that box, many of whom may be deceased or moved or whatever, depending on how old it is. So if you have bad contact information for fewer than 10 individuals, you can provide substitute written notice, and that could be some kind of alternative written notice by telephone or other means. But if you have more than 10, you have to provide substitute notice by posting a notice on your homepage regarding a breach, providing notice in the major print or broadcast media that will actually intended to reach the affected individuals where they reside. And these notices must include a toll-free number that individuals can call for at least 90 days to learn about the incident and if their information was involved in the breach. So if you have to post it on your website, you also have to get a toll-free number. You have to have it staffed and have it up for at least 90 days. Now, the content of the individual notice should include a brief description of what happened, including the date of the breach and the date it was discovered, if you know exactly when it was discovered, a description of the type of information of unsecured PHI that was involved, whether it was full name, social security number, date of birth, address, diagnosis. This is especially important if it has sensitive information that's been disclosed, like mental health, drug and alcohol treatment, HIV, and other things, because that's going to be more important for the individuals. And then you need to also include steps that individuals should take to prevent themselves from potential harm. This could be in things like advising them to carefully review their explanation of benefits or checking credit reporting websites. Again, you'll want to give them more notice about contacting the various credit reporting agencies if Social Security numbers have been disclosed, or if credit card numbers have been disclosed, because you want them to be able to, if credit card numbers have been disclosed, you want them to be able to cancel their cards. You want to give a brief description of what you're doing to investigate the breach, what you're doing to mitigate the harm to them, and to protect against further breaches. That may include things like additional employee training, updating email encryption, or developing new policies and procedures depending on what caused the breach. And again, you want to provide contact information for the entity, including a toll-free number for them to ask questions or get more information. So the next part of it is reporting to the OCR. And you have to report every breach of unsecured PHI via an online form on the OCR website. If the breach affects fewer than 500 individuals, then you have until the end of the February of the following calendar year to submit the online form, and so you can just submit them all at one time at the end of the year. You can maintain a log and then submit them all at once. However, you might also want to do them as they happen so that you don't miss that deadline and then get in trouble for failing to report. So you have to assess, whether you have people who can take ownership of that issue and do that. If the breach affects more than 500 or more individuals, you have to notify the OCR at the same time as you notify the affected individuals without unreasonable delay, and in no cases later than 60 days from the date of discovery. Breaches of 500 or more are posted on OCR's website, and this is often called the wall of shame, and it's somewhere you don't want to be, but you also don't want to be there and not be taking the right steps. There are a lot of entities on there, including some well-known ones. So additionally, if the breach affects 500 or more residents in a particular state or jurisdiction, you have to provide notice to prominent media outlets serving that state or jurisdiction. OCR said that if you have more than 500 but they're in different states or jurisdictions, then you may not have to notify the media if it didn't affect more than 500 in any one single state or jurisdiction. The notice to the media needs to include the same content as notification to the individuals and must be provided without unreasonable delay and in no case more than 60 days. However, it doesn't have to occur at the same time as the individuals, so you'll probably want to provide notice to individuals before notifying the media to try and minimize the public fallout. I've had clients who have provided notice to patients early and then waited for something big to happen in the media before they put a press release out there in hopes that it would not be picked up on too much. So There's also state law breach reporting in every single state regarding patient privacy, and it may require reporting of certain breaches involving personally identifiable information, and that's not limited to PHI. So it might be just if you have a patient and the Social Security numbers that get breached, you're going to be subject to the state reporting requirements as well. So there's a wide variance in how each state handles breaches. They might have shorter timelines to report. They might have a broader definition of protected health information, and they may require notification of additional entities or require different content in the notices. In Texas, we have both the Medical Records Privacy Act and the Identity Theft Enforcement and Protection Act, and I'm going to go over those. For example, Texas defines the term covered entity under the Health and Safety Code to include not only what we think of covered entities as under HIPAA, but also any person or entity that comes into possession of protected health information. In addition, covered entities have to provide training to employees within 90 days of hire on both state and federal law privacy issues. Also, under the Texas Business and Commerce Act, there are additional requirements on businesses that maintain sensitive personal information. That includes Social Security numbers, credit card numbers, etc. So you're under an obligation as a business to protect such sensitive information from unlawful use or disclosure. So if there's a breach of a system security of computerized data, and subject to certain exceptions, you'll have to provide notification of the breach to affected individuals. And depending on the location of the affected individuals, that notice might have to comply with state law in the state where the individual resides. Further, under the Texas statute, if the breach requires that the business notify more than 10,000 individuals, the business must also notify each consumer reporting agency that serves customers on a national basis. So Texas is really more of notify ASAP, not giving you a cushion as much, because with this kind of information, it's probably more sensitive financially and more likely to result in things like identity theft to the individuals who are affected. And so complying with all those different reporting requirements, they can take a lot. There's a lot of coordination that has to be done. There's a lot of review of, what has to be included, being truthful without making yourself look too bad, and really making sure that the individuals who are affected know how to protect themselves. Medical identity theft is a problem. It continues to be a problem. We thought that the ACA would help that. It hasn't necessarily helped that. So really giving patients notice and the opportunity to protect themselves is important. Also, depending on the extent of the breach and what was exposed, some entities choose to provide credit monitoring for individuals. That is not something that's required by law, but it's something that should be considered depending on the outcome, the cause of the breach, and the potential effects on the individuals who are affected. Now, that's another thing that cyber liability insurance can cover. So it's useful to consider that to help protect you from breaches. Often just applying for cyber liability insurance can help you give a really good picture of the state that your security assessment and risk management plans are in. And so that can be, even if you end up not getting it, that can be a good exercise in and of itself. So next, Allison is going to talk about responding to a breach.
Thanks, Beth Ann. So these next few slides are designed to kind of give you some practical tips on you've received information that indicates that you may have a breach, but you're not there yet. You haven't quite confirmed that a breach has occurred. And so these next slides give you some tips on how do you go about addressing that situation. So our first tip is, first you need to assemble a team, and the team should be assembled immediately and include senior management, such as the CEO, the organization's privacy and security officer, possibly the compliance officer, possibly the risk manager, just some senior managers who have the authority to act quickly, gather information, and make decisions. And depending on the facts of the situation, you may want to consider getting some outside consultants. Oftentimes, investigations might reveal information that could be harmful to the entity or to the organization if it were to be disclosed publicly. In such situations, it may be helpful to have an attorney on the team to help direct the interviews, the incident response, and try to pull as much of that information under the attorney-client privilege or the work product doctrine. When a breach involves electronic data and systems, a computer forensic consultant can be an invaluable resource. Such consultants can, among other things, help stop an ongoing attack, identify compromised data and systems, delete malware and other hacker tools from the system, and analyze systems to determine the extent of the compromise. If legal counsel is involved in directing the investigation, counsel should be the one to retain the computer forensic consultant as a contractor to also, again, help pull all of the information that's received from that consultant into the privileges as much as possible. And finally, if a breach affects several individuals, it may result in a significant backlash in your community and against your organization, then you may want to consider getting a public relations firm involved. These firms are quite skilled and useful in helping to guide organizations' notices and to limit the backlash and limit the harm to your reputation from any breach. So once the team is assembled and you have your key players and your response team, then it's time to investigate, analyze, and take action. The team should document key facts and interview anyone with knowledge of the incident as soon as possible. If an attorney is involved in the process, the attorney should participate in these interviews and assist in preparation of written documentations. The team should also, during the investigation, they need to ensure that everything remains confidential. So employees need to be directed to keep whatever they know confidential and not to share with anyone else unless the team authorizes them to do so. Additionally, the organization needs to retain all information and preserve it to the extent possible, just in the event that ultimately you have to report and it becomes public and there is an investigation from OCR or potential litigation arising from the matter. Therefore, the team will need to take steps to preserve the information and prevent it from being destroyed. The team needs to take steps to mitigate the harm. If the breach is ongoing, the response team should take all steps necessary to stop the incident, and the team will need to assess and implement methods to prevent additional harm and mitigate existing harm. For example, as Beth Ann discussed earlier, we're seeing it more and more where the entity will provide credit monitoring services to patients for a year in order to mitigate potential harm from the incident. Next, the team needs to take corrective action. For example, an employee whose inappropriate actions resulted in a breach may need to be disciplined, and you should have it where your policies provide that a breach of the HIPAA privacy rules and policies and procedures will result in sanctions to the employee. Also, you may need to provide additional training to your workforce and all of those other steps that Beth Ann discussed earlier that you will end up putting in any kind of individual notice. The response team will need to determine whether or not law enforcement or insurance carriers should be notified. For example, in the event of a cyber attack, law enforcement may need to be involved. The Department of Justice has recommended reporting to the National Cybersecurity and Communication Integration Center, which can enable the entity to share and receive information about an ongoing incident and receive technical assistance about that cyber attack. Additionally, if you have an insurance carrier that provides coverage of these types of incidents, then you need to notify them and see what your insurance policies will cover and assist with. Once the team gathers all of its information and does its analysis, it needs to determine if a breach occurred and what kind of breach reporting is required. And as everyone knows, and it's said time and again in the provider setting, if it's not documented, it didn't happen, so make sure you document everything. We recommend that one team member be assigned with documenting the interviews and steps taken by the organization. And it's much easier to document things as they're happening rather than try to reconstruct events after they happen. And whenever you document, it's important to document verifiable facts. Don't put in your opinions or your thoughts or your analysis in the documentation as you're doing your investigation. It should just be the facts. And then the analysis can be done elsewhere, and hopefully, depending on the situation, through your legal counsel, so that can, to the extent possible, be pulled in with the attorney-client privilege. And with that, I will turn it over to Beth Ann, who will talk about some tips to just make sure you don't get here.
Thank you, Allison. Lastly, we would like to provide a few tips that will help you prevent a breach and prepare for the inevitable. The HIPAA security rules clearly say that you have to conduct regular security risk assessments and implement a risk management plan. That includes inventorying the organization's data, where that data is housed, how it can be accessed, and then analyzing the risks to that data. After you get that information together, then you develop a risk management plan to minimize the identified risks. And you need to do that annually and periodically update it. For example, when you get a new system in, if you use a new vendor for your network platforms, if you move from servers to the cloud, all those things are going to affect your risk assessment. And I want to warn you that this is not something that you could say, oh, this is the IT department's job. While a lot of the ways to address risks are going to be implemented and recommended by your IT department, you really need a team of individuals who are very knowledgeable about the hospital's operations in order to see how the organization's data is done. You want to identify, so you might not think that purchasing or certain areas are going to have individual PHI in their systems, but they can, because if they're ordering things on a case-by-case basis, there might be PHI on that information. So you really have to take an entity-wide approach to the security risk assessment, and that means if you have physician organizations, if you run a rural health clinic, if you have outpatient departments, you need to think about how information is dispersed throughout the entire system. Because the first thing that if you have a breach that the OCR is going to ask for is your risk assessment. And, failure to conduct that and to implement risk management plans is one of the primary reasons that the OCR seeks sanctions against people in the result of breaches. For example, Fresenius Medical Care settled with OCR in 2018 for 5 separate breaches, each involving less than 500 individuals. But OCR found that they had failed to conduct an accurate and thorough risk analysis of risks and vulnerability to its data, and so they ended up ultimately settling for $3.5 million and had to implement a corrective action plan. Now remember, under the security rules, you need to protect the confidentiality, the integrity, and the accessibility of your electronic PHI. So we haven't talked about ransomware up in this presentation yet, but OCR does basically consider that to be a breach, and you need to have that addressed, and that would happen through your security risk assessment by having backup systems in place, so that if you have the right backup, then they can only take a certain amount of data, and you can still keep operating. Encryption is just, if you don't have encryption right now, then you are really likely to incur a fine. That's my personal opinion, because encryption now has become so widespread and is such the standard, and it's really very easy and not very difficult or expensive to maintain right now. So even things like flash drives, thumb drives, laptops, if you are using mobile phones for communication, if you have anybody with a residency program, that's all they do is text things back and forth. All of these things can and should be encrypted. And like Allison mentioned, encryption is not going to matter if you're actually open and using the computer. So you also have to have policies as part of your risk assessment. What kind of Wi-Fi network they're on. If you have someone with an encrypted laptop, viewing patient data at a Starbucks, that's an open Wi-Fi connection, is not secured, and the encryption is not going to help you one bit, because that's open and that person can be hacked. A high number of breaches arise from employee errors, and so you really need to take the time to train your workforce based on issues like privacy and security and your policies and procedures and all that. The biggest problem is when employees compromise their login credentials by clicking on links and phishing, the PHISH phishing type of emails. It'll look like it comes from like your software vendor and say, if you don't log in and change your password, you're going to have to, you're going to lose access, or something bad's going to happen. You need to train your employees to identify that. And actually, Microsoft has some really good online materials on how to train your employees on not responding to phishing emails. And so I would recommend that. There's a lot of online sources for that. Business associates are another likely source of breach. The big Target breach was actually caused by their HVAC vendor. That was, however, but 75 million people's data got stolen because of that. So before you go into business with go into a contract with a business associate, you need to vet them to determine if they have effective security programs. If you're talking with them and they're offering you a great price, and you ask them, "Oh, well, how's your HIPAA compliance program?" and they say, "What's HIPAA?" That's a problem. So you want to try and negotiate. First of all, confirm that they know what they're talking about. Negotiate the best terms possible. You want to have a short time frame for reporting breaches. If you can, get them to carry cybersecurity insurance to cover the cost of any breaches that are caused by them, and actually get them to make representations, regarding their responsibility and their training in those business associate agreements. So that's all we have for today. We really appreciate the opportunity to discuss this very important issue with you, and we'll be happy to take any questions now or offline. But first, I would like to tell you two things. There's going to be a 4-question survey that's going to pop up. If you'd please take a minute to answer those questions, that will help us to develop further content that will be useful to you. And then also, I would like to remind you that our next webinar on July 11th is going to be regarding surveys. We'll have emails out ahead of time in that. And with that, if anybody has any questions, we'll take those. Otherwise, we look forward to having you join us for the rest of the webinars in this series. Allison, I see there's a question there. Allison?
Sorry, I had you on mute. We received a question and asked if we were going to make these slides available, and we will email these out to the attendees. Also, so you know, we are recording these webinars and putting them on our website. So if you decide you want to have someone else in your organization listen to this webinar, then it'll be up within a week or two, and you can just access them on our website. Also, so you know, you can unmute yourself and ask questions if you don't want to type them into the screen. Well, thank you all again for attending, and we look forward to our next webinar in July. And like Beth Ann said, we will send out email reminders for that, and we hope you can join us. Thanks again.
Thank you.